Welcome back to This Week in Immigration, the Bipartisan Policy Center's podcast for immigration nerds. I'm Hannah Tyler, research analyst for BPC's Immigration Project. This week, we're focusing on the immigration courts, specifically the deep problems that we see in the immigration courts and attempts by some lawmakers to fix them. In the first half of the episode, we welcome special guest Congresswoman Zoe Lofgren of California to discuss her Real Courts Rule of Law Act of 2022. Then we'll be joined by Austin Kocher of the Transactional Records Access Clearinghouse at Syracuse University and Chen from the American Immigration Lawyers Association to discuss the current state of the immigration courts and why change is necessary. Stay tuned.
Welcome back. We're thrilled to welcome to This Week in Immigration Congresswoman Zoe Lofgren, who represents the 19th District of California. Before serving in Congress, and she started in 1995, she worked at an immigration law firm, and she served on the board of San Jose College. She has been a longtime member of the House Judiciary Committee and is currently the chair of the Subcommittee on Immigration and Citizenship. She has also been at the forefront of many efforts to reform America's immigration system through legislative action. And her recent bill, the Real Courts Rule of Law Act of 2022, or H.R. 6577, seeks specifically to address the status of the immigration court system. Welcome to the podcast, Congresswoman.
Thanks so much for having me on.
Well, can you give us some background on the bill itself and why you chose to move it forward this session?
Yes. The state of the immigration courts has been of concern for a number of years, but I think it really came to a head under the prior administration when the lack of independence became so starkly apparent with the Attorney General making changes in decisions. The Attorney General's not in the courtroom when facts are applied to the law. And it seemed to me that this has been a problem for a long time. But now that we have a Democratic administration that's not engaging in the kind of conduct as the last administration, it seemed like a clear shot in a way, because the need for independence in the courts is present no matter which party is in the White House. I mean, people expect when they go to court to have independence, to have their case heard based on the facts, based on the merits, and not be politicized, which is the situation that we have today. There are different ways to approach this, but we spent a very long time getting input from knowledgeable sources, from the Federal Bar Association, from the immigration judges themselves, from the ABA, and came up with a plan that we think is a solid one. It's basically, in some ways, modeled after the bankruptcy courts, where you have a specialized area of the law, but you have judges that serve for a term of years who are independent in their decision making, and we think it's a good model for immigration.
Yeah, I mean, there's a lot of people that don't understand that immigration courts aren't courts that we traditionally understand them as, like in the judicial system. So your bill specifically would make them like regular courts. What specific issues do you think that making them an independent court will address? You mentioned the influence of the Attorney General. Are there other things that you think bringing the courts into their own independence would help, like maybe any of the backlogs or how the judges can decide their cases?
Well, I don't necessarily believe this move will have an impact, pro or con, on the backlog. Okay. It's about the integrity of the system. When you really, the foundation for our legal system is respect for the rule of law. And fundamental to the rule of law is that it's impartial, that judges will make decisions based on the law and the facts, not on political influence or any other factor. And so this is really important, not just for immigrants, but for American society, to have a legal system that we can respect, that we know is independent, that we know is apolitical. That's really important. And it's something that we expect in every courtroom in America. This should be no different.
So it sounds to me a little bit like maybe your background as an immigration lawyer has influenced this a little bit, and lots of years at Congress. Is that one of the reasons why you feel like you're the right person to take this on right now?
Well, I practiced immigration law and taught immigration law a very long time ago. So I don't know what influence it has, but I chair the immigration subcommittee and serve on the courts committee, so they have a piece of the jurisdiction as well. And it seemed to me, whether we can get this done in this Congress, we don't know. But we're hoping that they can get back to what the Constitution provides at some point. And I do think getting this issue out there, having it critiqued, and getting some momentum is important for getting this done.
Yeah, no, I know you already had a hearing in your committee on the bill. Are there other things you are trying to do to sort of get that momentum going, or do you need kind of some external push?
Well, we've had a great support, as I say, from the Federal Bar Association, from the American Bar Association, from the immigration judges, and I think from advocacy groups as well. I'm hopeful that kind of support will draw attention to it. We were not able to get a Republican co-sponsor on this bill despite substantial efforts. And I think many of my colleagues on the other side of the aisle are just very, I don't know if nervous is the right word, but very aloof when it comes to anything that relates to immigration. However, this is not really an immigration issue. This is a rule of law issue. And I'm hopeful that as these discussions occur with members of Congress in both parties, that lawyers from their own districts can point out this is not an immigration bill per se. This is a rule of law bill. And hopefully we'll get the momentum we need to move it forward.
Well, I appreciate you taking the time to talk to us about this bill. Thank you very much to our guest, Congresswoman Zoe Lofgren, for speaking to us this week.
Thanks so much.
And we're back. So now I'd like to bring in two people who have some more direct experience looking at the state of our immigration courts. Austin Kocher is assistant research professor at Syracuse University and a researcher with the Transactional Research Access Clearinghouse, where he focuses on mapping and analyzing large federal data sets relating to immigration and trends within the federal, criminal, and civil courts. And you can follow him at AC Kocher. That's Kocher. He's a good follower. He's a good person to follow on Twitter. So welcome, Austin.
Thanks for having me.
We're also welcoming Greg Chen. Greg is Director of Government Relations for the American Immigration Lawyers Association, otherwise known as AILA. Before joining AILA, he worked for the Lutheran Immigrant and Refugee Services and the U.S. Committee for Refugees and Immigrants, and you can follow him on Twitter at Greg Chen AILA. Welcome, Greg.
Thanks for having me.
So, Austin, I'm going to start with you because I think it's always good to ground some things in data. Can you give us an overview of, we hear a lot about the backlogs in the immigration courts. Just where do these backlogs currently stand? And what are the kind of most salient problems that you're seeing from the data that immigration courts are having?
Sure. So we just released data about an hour ago, actually, that showed there are a total of a little bit more than 1.7 million cases currently pending in the immigration court system. To put that in perspective, if that was a city, that would be the 5th largest city in the country. That's more people than live in Phoenix right now, which is currently the 5th largest city. So it's pretty large. When I started that comparison, I was starting with like the 9th or 10th city. This was last year. So you can see how quickly the backlog has grown. It's grown really quickly in the last couple months. But just to put it in more historical perspective, 5 years ago at the start of the Trump administration, we had a little bit more than 500,000 cases, a little bit more than 500,000 cases pending. And we thought that was really large at the time. If we go back 10 years, that number was about 325,000 cases. So it grew about 175,000 cases in 5 years and then shot up dramatically during the Trump administration. And even though we've seen the numbers of cases in the backlog grow pretty dramatically in the last couple months, we wrote a report on this recently, the context for that is both, still the consequences both of the Trump administration, large numbers of new cases being filed, as well as the consequences of the pandemic, which has made it the immigration judges have not been able to get through cases. So number of factors drive that number, but it is higher than ever.
Yeah. And so it's an inflow outflow problem. You have more cases coming in and you're not completing as many cases because many, many immigration courts were shut down during the pandemic. So they weren't able to complete cases. And you've talked about how the backlog has changed. Greg, let me ask you, what have your members been telling you about their experiences with immigration courts? What are the issues that they're seeing aside from just long backlogs and delays? Why do they think reform is so needed?
So that's an excellent question, and I'm so glad that we started here with what's happening with the courts today and with the backlogs. Of course, as you've already flagged, the long delays are a big issue. An issue that comes right alongside that is concern about how court operations are going to happen right now. We're still in a pandemic era court operational situation where courts rapidly scaled up the use of virtual hearings. Some of that during the initial period of the pandemic was because of health concerns. People couldn't come into the courts physically, including the judges and personnel, as well as the respondents and lawyers themselves. But since the health protocols have gotten better, and since the pandemic has subsided and we're opening, what we've actually seen happen now is that the court has increasingly relied upon these virtual hearings for convenience purposes, because it's helpful for the court to schedule not in person, but to do them virtually. And one thing that our members are concerned about is that this actually makes it hard for them to request an in-person hearing. And as anybody who has represented somebody in immigration court knows, the importance of a judge being able to face-to-face see a witness, see the respondent, talk about something that's happened to them is typically essential for that judge to be able to assess, is the person telling the truth? Credibility finding is one of the key elements. And so many of our members are concerned about this practice. The other thing I'll just flag here is notice of hearings and how the calendar is working. The court is still trying to stand up effective methods for making sure that people know, is my hearing actually going to happen on this particular date? And oftentimes what we've seen is just somewhat haphazard methods of providing notice, people not knowing which judge or whether a case is actually going to move forward. Some of that is caused by the pandemic, but much of it is actually due to long-standing inadequate notice procedures by the court. It sounds really fundamental, and yet the immigration courts still don't really have their act together on this.
And we've also seen and heard that the immigration courts are still very much paper-based organizations. They don't have a lot of things electronically. Does that also hinder their ability to give adequate notice or to allow electronic filings that could be a little bit more expedited through the process rather than having to wait on case files to come from place to place?
Another good question on this front. I think there's been evolution and development by EOIR to try to become more of the current century where everything is electronic. But it is slow, as is U.S. Citizenship and Immigration Services, as the other agency that handles so many immigration petitions and applications. So there is a new system that EOIR has started to set up, but there are still many kinks that need to be worked out. And we hear a lot of complaints from members about the system not quite working right, not having correct instructions for how it should be done, and sometimes accelerated procedures that actually impose burdens on the respondent to be able to use this kind of a system. And so that'll take time to work out. I think AILA's overall concern is just to make sure that the need for speeding up court procedures, which we generally agree with as a benefit to have efficiency, that not be used in any way to compromise the respondent's need for fairness and adequate time to prepare for their case.
Yeah. So that brings us to the piece of legislation we were talking about with with Representative Zoe Lofgren, the Real Courts, Real Rule of Law Act. And, the fundamental issue for that bill is to take the immigration courts, which are currently part of, as Greg, you mentioned, EOIR, the Executive Office for Immigration Review under the Department of Justice, and make them independent, that Congress can authorize creation of new independent courts, judiciary in the United States.
So at the most basic level, I think it's important to emphasize that Zoe Lofgren's bill is fairly straightforward. What you just described there, Teresa, is 90% of the bill. It's a simple, good government reform that transitions the immigration court system into an independent court under Article 1 of the Constitution, which is the legislative branch. And that's important because it currently sits in the executive branch's authority. And the most important piece of that is that while it sits underneath the control of the executive branch and Department of Justice in particular, it's more vulnerable to the political priorities or the policy priorities of the executive branch. And past administrations of both political parties have taken the opportunity to insert their policy priorities onto the court. And that does have damaging or harmful impacts at times. Not always, but at times it has, because there is this inherent conflict of interest of functionally the chief prosecutor also being, in a sense, the chief judge in immigration court matters. How does it impact the day-to-day basis, day-to-day issues? Well, what we've seen happen is when administrations impose their policy concerns upon the court, it compromises at times the independence of the court. And here's a specific example. Previous administrations changed the docketing methods, and this is actually under President Obama. And they created certain kinds of special dockets because they wanted to advance certain kinds of cases. That's not necessarily the wrong type of decision to make, but it functionally put the executive branch's goals of which cases are important over perhaps the court's own set of priorities. And then a new administration comes in and says, well, we're going to do it differently. And what that functionally does is it makes the court slower. It actually slows down operations because first, one set of cases are super important. And then 3 years later or 4 years later, another administration comes in and says, well, we actually want to handle these cases, or we're going to shift them to a different location geographically. And suddenly you lose your caseload, a whole nother judge needs to come on board. And so it certainly slows down the courts. And I think the more significant concern for practitioners and respondents is not just the timing here, but it's also that it might compromise the fairness in hearings if judges have pressure put upon them directly by the executive branch to speed up their cases. And so one thing we saw happen under the Trump administration was quotas put on judges that were part of the Trump administration's priorities to speed up the cases. But this meant judges were supposed to handle and close up to 700 cases a year. And the problem is that the judges are underneath the control. They're actually the staff members of DOJ. They're not judges per se. They're actually employee staff of DOJ. And so their personal evaluation, their job review, is subject to this actual number of cases they close. So it's a direct correlation that they will feel that pressure to close cases. Well, the concern is that they will speed up decisions, and that could mean that they are more likely to deny a case because it's actually easier. It's less risky for a judge to deny a case than to grant a case.
Yeah. So I think it's worth just reminding our listeners who aren't familiar with immigration courts that they're not courts under, like we think of our criminal courts or even our civil courts, that they are a branch of the executive branch. Immigration judges, as you mentioned, aren't judges in the traditional sense. They're employees of DOJ. The prosecution of immigration cases in immigration court is handled by attorneys from Immigration and Customs Enforcement, who reports ultimately to the president, as does the judge report ultimately to the president. So if you're thinking about immigration courts the way you would a civil or a criminal court, they don't have, as you said, that same type of independence. And so that's what this bill is trying to adjust. Austin, I'm going to turn back to you. What's your sense of what impact moving the courts from DOJ may have on just the data and the numbers? I mean, Greg was talking about these docket changes and prioritizations. Have you seen that in the data, like case completion rates changing as those policies have changed?
Sure. And, Greg raises such an important point there that every time a new policy comes down based on the, political perspective of whoever is in the White House, it forces judges to jostle things around all over again. That's hard for judges. I know judges have spoken out about this being a major inconvenience and a barrier to productivity. Attorneys who are in court, both attorneys for ICE and also, more importantly, respondents and their attorneys, also face all kinds of challenges here too. If you've done all this work to prepare for a hearing in 2 months and now it gets kicked down the road for 3 years, a lot of that work is going to have to be done over again. And by the way, because, these policies are influenced by who's in the White House, the law may be completely different by the time you get to court. And so and that creates all kinds of efficiency challenges. We also have, a challenge here with, many people may not be aware that in the immigration court system, it's civil, not criminal. So not everyone has an attorney. So one of the efficiency challenges here is judges have to spend a lot more time with cases if someone doesn't have an attorney. So representation is also a really important factor, and that may change, if the courts are more independent. I think one of the big questions that gets asked, and I'm aware that that people in Washington, have this question. Well, if the courts are independent, is that going to solve the backlog? And the question is, maybe it will, maybe it won't. It seems like on the one hand, it could, limit some of the influence of political decisions that creates inefficiencies. So that would be good. Will that solve the backlog in itself? Maybe, maybe not. But I think it's important to sort of to step a little bit away from the backlog and thinking about the backlog as sort of the measure of everything and the screen by which we view everything. Because, to Greg's point, it's not just a recent issue, this independence problem. When we go all the way back to the creation of what were immigration hearings before judges wore robes, before, some of the policy changes in recent decades, go all the way back to the late 40s when this system was sort of, being born in the Department of Justice. There were concerns then. There were lawsuits that went all the way to the Supreme Court, arguing about whether or not these prosecutors in these hearings were being held in a fair and impartial manner. And consistently, the ruling was that they're not, but it's exceptional because it's immigration. We can treat immigrants differently than we can treat citizens. And so I think this bill is important, not just because of the practical problems that it can and will solve and that it may help solve, but also because it's the right thing to do. And it's been something that has been a very long time coming. And I think when we look at the immigration restrictions that we've created, Congress has created lots of restrictions around immigration with the premise that the United States is a desirable place to come for migrants because the United States has a measure of prosperity and follows the rule of law and doesn't operate like an autocratic or totalitarian kind of system where you've got one leader who can sort of dictate things to the courts. But then guess what? We have this whole court system within that system, which is effectively, at the sort of whim of whoever is in the White House. Again, not completely, but to a large extent. And so we've got this weird exceptional court system that is baked into how things work that has never really been fully lawful and has deserved to be independent for a very long time. And so I'm very glad to see this bill, proposed and hopefully it will be implemented.
Yeah. So, in addition to the independence of the courts, I think given the backlogs and the fact that we still see a lot of cases being entered into the system and a lot is so much dependent on what happens, for example, at the U.S.-Mexico border, in terms of the caseload that the courts can perceive. If it's made independent, it's still going to need additional resources and probably need to grow by a lot more judges and courts to be able to handle that. So that's probably a separate conversation, at least in terms of appropriations and how large the court system will be. Greg, do you think that there are other steps besides this bill that could help make immigration courts fairer and address some of the issues that we've been talking about today?
There are a number of other steps. Maybe before we jump to that, if I could also just amplify some of the important points that you and Austin were making before. One thing that's important to just recognize about this bill, since we're talking about kind of the policy impacts of executive branch concerns, this bill is really designed to try to minimize that as much as possible. And at the same time, for that reason, it's studiously intended to not add immigration policy legislation into the bill. It is very much a simple bill that only addresses the building blocks of the court.
So the new court would still be bound by existing immigration law?
Yes, and by and large,
Okay.
its jurisdictional powers, its operational pieces would be imported from the current court into the new one. Steps would need to be taken to make sure that regulations are done to have the new court operate as it should. But the main immigration law components are not changed at all under the new bill. And that's important because we understand immigration is very controversial, and it's often difficult to get the two parties to, members of the two parties to come together on a bill. And that's why we tried studiously in working and in talking with the champion, Zoe Lofgren, about it. She wanted to make sure that this bill could be acceptable on the Republican side, so we kept all that out. With respect to your question, Teresa, just in terms of what else needs to be done right now to improve fairness in the courts, et cetera, one thing that AILA very much supports, which Austin flagged a moment ago, is the need for legal representation programs. Study after study, historically, looking back decades, where law professors have studied people's cases who are not represented compared to people who are represented, the most important factor as to whether or not somebody is likely to get a fair hearing in front of a court is whether they have an immigration attorney representing them. So it's literally, you are likely to have a grant of asylum that you are 8 to 10 times more likely if you have an attorney compared to if you don't. And so that's a striking, dramatic difference. And it really comes down to people who are too poor, who are too indigent to be able to pay for an attorney. Counter again to popular conception of, let's say, the criminal court, you don't have a right to an attorney. You're faced with a life and death decisions oftentimes when you appear in front of a judge. You might be deported to a place that is very unsafe for you, and yet you don't have the right to have somebody appointed for you if you can't afford that attorney. So AILA has urged the administration as well as Congress to make sure to expand these kinds of programs. So that's one important step. And as Austin flagged, it also helps improve the efficiency of the court, just because when you have a lawyer there explaining what's going on, the judge doesn't have to do all that pre-explanation before a hearing can actually start. There are other steps that we think the Biden administration needs to take to make sure hearings are more fair. And that is, first of all, to try to make sure that the procedures the court uses are not going to be so restricted that judges can't make the right decisions in the case. Unfortunately, under the previous administration, some rules were put into place that basically took away existing authorities of judges to grant let's say, a delay in a case, or to take a case off the docket if it wasn't ready to move forward. These were done with the purpose that cases should be sped along as fast as possible. But what it actually does is it slows down the cases and is not efficient, but also puts pressure on people to move their cases forward. If you don't have an attorney yet and you can't get a continuance in the case and you're forced to move forward, well, that would be incredibly unfair. Especially if you are seeking relief that's going to be critical in your life, which is very much the case in most immigration cases.
Yeah, I think it's important to say, obviously you have statistics to say people who are represented are more likely to get relief, but some people would argue that, okay, well, that just means that, the judges are being pressured or whatever, that the cases are more lenient. But I think talking about the efficiency piece of this, Austin, I'm sure you have data that say, how much faster do cases move when someone is represented? How much quicker how much more likely are they to show up, right? We hear about that all the time. People come into the United States, they apply for asylum, and they never show up for their court hearings. Mm-hmm. Does representation matter in those kind of data as well?
Yeah, absolutely. And that's one of the things that's the clearest. And it comes at an important time when the Biden administration is rolling out all new alternatives to detention, monitoring programs and major multi-billion-dollar contracts with private, firms to monitor immigrants to make sure that they show up for their immigration court hearings. We know what works for immigration court hearings: having an attorney. And so we've looked at the data. We looked at about 45,000 cases that the report's about a year and a half old now, but when we looked at it, it was about 43,000 cases of recently arrived immigrant families in the United States, who the vast majority of whom were here to apply for asylum, and more than 99% of those who had an attorney appeared for all of their court hearings. Those that did not have an attorney appeared less often, still quite high, still more than 75%. But it speaks to Greg's point about the importance of an attorney, not just in terms of making a quality of a case, in terms of the legal case, but doing the translation work of explaining, what that hearing document means, that immigrant may get that document, may not read, be able to read that document or make sense of that document. I mean, I look at a lot of these documents too, and this is sort of my research area. I get confused by lots of these documents, right? So it must be hard to be, an immigrant in the process. And an immigration attorney does all kinds of extra work to make sure that that person understands what they need to be doing. And that's one of the reasons there's such a high, rates of appearance for people who have an attorney, not just outcomes, but all of the other procedural things. One other thing I wanted to note, in addition to Greg's comments, was, many people may not be aware that when that immigrant goes to immigration court and is going through the immigration court process, the ICE attorney that's sitting across from them at a table has all the information. They have the file, they've got, all the documents related to the case there. There's no mechanism for that ICE attorney to just hand that file over to the immigrant or to their attorney. We have this convoluted system where the attorney and the immigrant has to file a Freedom of Information Act request.
So there's no automatic disclosure like in civil or criminal.
There's no disclosure. There's no discovery, right? So they've got to go through the Freedom of Information Act process, which is another huge backlog. And currently, immigration-related requests, FOIA requests, are the bulk of FOIA requests that the federal government receives. It's a massive backlog system in itself, and that is yet another kind of one of these backlogs that the current arrangement of the immigration court system produces. So it's not just the inefficiency.
An independent court could have that procedure.
Right. There's all kinds of knock-on benefits to fixing, parts of this system.
Yeah. Well, Austin and Greg, thank you so much for this conversation. I've learned some stuff that I didn't know about immigration courts that I thought I knew a lot, but I'm sure our listeners have learned a lot more. Thank you very much, Greg Chen from ALA, Austin Kocher from TRAC at Syracuse University. Really appreciate you being here on This Week in Immigration.
Thanks for having me.
And that's it for our show this week. One last reminder to subscribe, rate, and review this podcast on Apple Podcasts, Stitcher, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find more information on all the issues we discuss here on the show at bipartisanpolicy.org/immigration. I'm Hannah Tyler. This Week in Immigration was created and executive produced by Teresa Cardinal Brown. This week's episode was written by Hannah Tyler, Teresa Cardinal Brown, and Hanadi Jordan. Ethan Plotkin produces and edits our show. The executive producer of BPC Podcasts is Lucy Manning. See you next time on This Week in Immigration.